In the last class, just we go for a small conversation, okay? Just listening out, listen out. We did it as two sessions. One is completely about introduction, and another one is from Indian Contract Act. So I'm trying to recall here from Indian Contract Act. Okay. So we started with a definition of what do you mean by agreement. What do you mean by agreement? There'll be 2 points. One is two parties will be involved, and in particular, minimum two parties, which means there can be more than two parties also. And consensus addendum, which means understanding in the same sense. Okay, understanding in the same sense. Then we were discussing on the types of agreement. Yes, please. What are the three types here? Social agreement, void, and legal. In particular, when we say social, is about the two parties who are under family arrangement or love and affection. So we can use the term called as family arrangement also. Okay, family arrangement also. When we say void, again we can say this in two ways. One is incapable parties entering into a contract. There is no capacity that way, or it can be illegal. Okay, illegal is different, incapable is different. Okay, but both will be called as void. Okay, and legal agreement is what we call or what we define as the next step, contract. Okay, so contract is something, an agreement which has legal enforceability. Then we were discussing a contract to be a valid one. We need to have 10 essentials, and the 10 essentials starts with here one, minimum two parties, consensus addendum. Let me list out the third point over here. Yes, please join. Consideration should be there, which means I cannot do as a free thing to you because it's not a family arrangement. So what we do here, we go for consideration. Consideration means something in return, and that should be lawful. Okay. Fourth one, object for what I'm entering into this contract, and that object should be lawful. So object is nothing but the subject matter of the contract. Okay. Then fifth one, so this is lawful. Formalities. Depending on the subject matter, I may be having different formalities. So that formality will be called as not lawful but legal because we'll stick to the specific act, no specific rules and regulations, whatever we have. Sixth one, relationship. We are very sure and we are confirming that it is a legal which is not a social in nature. That's why the relationship, which means the legal intention to be created, will not happen in a social agreement. May happen in a void agreement, but we are not going to consider because it becomes illegal or incapable person entering into it. So here becomes the legal relationship. Let me go for next 4 points. Seventh point, who can enter into a contract? Capacity of the parties. Eighth one, there should be the parties have entered without any compulsion. Okay, without any compulsion. Ninth one, certainty and possibility should be there. So certainty means I'm not just going to buy 100 shares. I'm going to mention when it has to be delivered and how much amount I'm going to pay. I'm going to pay in installments or whatever it is. All the terms and conditions should be mentioned. And also you have to check whether it is possible to perform that action. Possibility means we'll talk about legal possibility and everything. Okay. And 10th one, yes, not expressly declared as void. Not expressly declared as void. Which means even though all the above 9 points are there, these are the 9 points associated with the contract while you enter. That period, that date, that time, your capacity, everything matters over there. So it's all happening during the entrance. Okay. But what the 10th point says here is not only during entering into a contract, even after that, after execution also, what you have to do? You have to check all these validity. So not expressly declared as void. Is it okay? So not expressly declared as void. So if these 10 points are there, we'll call the contract as a valid one. Else the contract will become invalid. But in law, we will never use the term called as invalid. Okay. Instead, we are going to use some other terms called as void, void ab initio, voidable, unenforceable. These terms will be used. Is it okay? So I'll continue from single material. You can please join from single material here. Definition, essentials and types of a contract. Definition, essentials and types of a contract. You need not make a note of anything. If you want to have some scribblings and all, you can scribble. Okay. So just don't go write everything and come. So that's not necessary. See, whenever we come to learn about an act, you should be very sure that what the section one says. Every time when an act is defined, the section one will talk about the scope, extent, that is applicability. We are talking about applicability. And from where it is applicable, scope, extent, and applicability and all. Where it is applicable, for whom it is applicable, for which area it is applicable, okay, from which date it is applicable, for whom, everything. If you ask all the WH questions, everything will be applicable here. Okay. So from section 1, you can clearly define. And also along with that, when an act comes in an official gazette notification, it clearly says whenever we mention in between any provisions, whenever we mention the act, it is meant the act we are discussing here. Here we are discussing Indian Contract Act. That's why if we use that word the act, we are mentioning about Indian Contract Act. If we are discussing Companies Act 2013 and anywhere you find the act, we are talking about Companies Act. So whenever we talk, when we find this word the, we are discussing about that particular current act we were discussing. Okay. So when we say the act, which act we are referring? Indian Contract Act 1872. It extends to the whole of India. This is what we call as the geographical jurisdiction. Okay. What do you mean by jurisdiction is how far, which area it's applicable. It's applicable to the whole of India. You enter into a contract with a person in Tamil Nadu, you enter into a contract with a person in Jammu and Kashmir, Indian Contract Act is applicable. You enter into a contract with a person in Maharashtra, you enter into a contract with a person in England, the Contract Act is not applicable because the name itself says it's about Indian Contract Act. It's happening between the two parties, and it's very clear when we say two parties, the two parties will be of Indians. Now the problem arises. There's a foreigner arriving to a country, visiting us as a tourist. Is this applicable? Yes, it's applicable because what they say extends to the whole of India. Okay. From when it's applicable? 1/9/1872, and we were also discussing this will not have retrospective effect, which means all the contracts entered from this date on or onwards, then only it's applicable. If anything entered before the date and executed after the date, it's not applicable. So if a person has entered into a contract, two persons have entered into a contract on 31st August, when 1872, then this act is not applicable. And also law says when we mention a date, from which time it's applicable. From midnight, 12 o'clock. When we say day, it's covering 24 hours. Okay, whenever you use the term day, it's covering 24 hours. From which time it's applicable? From the midnight. Okay. Also, we need to know what is the background of the act, why we need to have this act, and so on. So the prior law says here will be following English common law, so we can easily understand from which year it is applicable. 1872. If we go for the independence of India background, we have 1947, 1950, the Constitution of India. Okay, we have this charter document. When we say 1950 charter document, Constitution of India, all the things happening before is called as pre-law, pre-constitutional law, and all the things after happening after this date will be called as post-constitutional laws. Okay, we are not worried about this date. See, we got this independence, but we have this own charter from 1950 onwards only. So you remember the date, 26th January 1950. Okay, so this date is 15th August. Okay, and if you go for this independence background, before this period, some 200 years, under whom's control we were? British England's control. Okay, so this year 1872 is completely under whose control? British control. That's why we follow our English law. So we call this as English common law. Okay. But the beauty of our nation is we have all religion based, diversified culture. Okay. We have Hindus, we have Muslims, we have Christians. Obviously, when we talk about the English law, England, they're all Christians. Okay. But what happened is we have to refer these Hindu and Muslim law also. So we are referring the prior laws, not only English common law, but also Hindu and Muslim personal law. We'll call it this as religious laws. Okay, Hindu and Muslim law. Probably will not be studying more about these religious and personal law and all, but instead what we do is in the question it may be asked as A and B are two Mohammedan brothers, or A and B are Mohammedan husband and wife. It will be mentioned in that such a way, or it will be mentioned that X cut down the family enters into an agreement, so on, so on. So only in that wordings will be highlighting this one. Other things are not will not go into. Okay. Division I have taken as four. What's the schema of the act is? Schema means structure of the act is. We have from section 1 to 266 in number, but 1 to 75 completely deals with general principles of contract. Again, please try to remember, as I was discussing in the earlier class, I was mentioning that 70 to 80% of the Indian Contract Act will study about how we'll discuss on validity, all the 10 points. So 1 to 75 sections completely dealing on general principle, which means for a contract to be a valid one, for a contract to be a valid one. All the 10 points will be discussed. But whereas if you go for sale of goods, probably as far of your knowledge, if you know the meaning, this is the goods means, please take it away. Okay. Because when we discuss sale of goods, we'll discuss what is the goods, what is the not goods and all. Okay, we'll discuss that later. When there is a sale happening, sale of what? Goods. When there is a sale happening, the provisions related to sale is different, the provisions related to barter is different. Again, Indian Contract Act is not defining with respect to barter, it's just consideration. It can be anything in return, something in return. What do you mean by consideration? I give something and I take something. It can be anything in return. So when we say anything or something in return, it need not be money only. Sale is something which is associated with money in turn. And sell something which are expecting money. But Indian Contract Act is not discussing with this, but it discusses with barter. Okay, anything you take and anything you give. So we need to have specific provisions, even though we are following Indian Contract Act, we need to have specific provisions. That's why 76 to 123 section is repealed, will not say it's removed. Removed means it's completely done, okay. But in legal term, we'll use it called as repealing, repealed. And this is now we have as a separate act called as the Sale of Goods Act. From which year this is applicable? 1931. Probably let me go for the very first page of this Sale of Goods Act. Can you please turn over and check? Can you go for this very first page of the Sale of Goods Act? Yes, please. What is this? Introduction. I just want to define only this word. What it says here? Subsume. There we were referring repealed. We have two words here. You can please make a note of these two words. One is repealed and another one is subsumed. Is it okay? Repealed means it is being taken away. Okay. Taken away from the current act. From which act we are referring here? Indian Contract Act 1872. Okay. Those provisions 76 to 123 sections are being subsumed from where? The Sale of Goods Act, SOGA 1930. Whenever we talk about an act, we have to talk about the background history. So whenever you go for referring SOGA, definitely we are going to talk about Indian Contract Act, which means it's been not the provisions followed exactly, but you can some alternatives are done, like sale is involved, money is only involved as consideration, etc. So subsumed means from where it is taken, repealed means it's taken away. Is it okay? Subsume and repeat. I request you to go for the legal meaning. Go for referring the Google search the big words and get the real exact meaning, legal meaning. You'll find two dictionary meanings. One is the normal Oxford, I think. Okay. Another one, Oxford or Cambridge meaning you'll get. Another one you will get it as legal meaning. Whenever you start finding some legal dictionary meaning, you will get the answers hereafter as legal meaning. Okay. So you can please make a note of it. Again, back to Indian Contract Act page. Then 124 to 238 deals with special contracts. In case of pledge, what happens? In case of bailment, what happens? In case if you are entering into a contract with an agent, what happens? So these types of special contracts are discussed from these provisions. Again, we have this in our syllabus. We'll do this later. Now here, 239 to 266. It's not a partnership business. See, just I will try to link this point. X and Y are two persons. The relationship between them is husband and wife. If they enter into a contract, is the contract valid? No, because they are not creating legal relationship. Okay, but this two persons, husband and wife, they enter into a contract to do a partnership business. Okay, partnership firm. They are running a firm. Okay, they both together run the business and they are selling the goods to a third party. Here we cannot barely use the provisions of Indian Contract Act. Instead, what we are doing, we need to have special provisions on it. What are the rights the husband has? What are the rights the wife has? It's not only between husband and wife. It can be any two persons involving in a partnership firm. It can be any two persons, but still, the Contract Act is not discussing on the specific things. That's why it's also repeat, and we have a specific act called as the Indian Partnership Act, from which year? 1932. So these both the set is not covered at Indian Contract Act. So from where to where we have 1 to 75 and 124 to 238. And this table is a beautiful table which are not covered, even though it looks like as if we are following Indian Contract Act, but these things are not covered. No, there's no prescribed rights and duties. Law says there is a consideration, there's a lawful object, etc., but you can have any as consideration. Okay, which means you can have any rights, you can have any duties, you can create your own rights and liabilities, but it should be within the limits of that. It should not be illegal. It should not be happening within the family members and so on. Not the whole of the agreements. What do you mean by this term whole of the agreements? Means sometimes the agreements may be entered because of maybe of political nature, social nature, religious nature, or other agreements where legal intention is not covered. I want to highlight this. Probably there are some religious cost involved in building a temple, like a Kumbhabhishekam or something like that. And I am giving as a donation 10,000 rupees. Is this covered in the Indian Contract Act? No, because there is no legal intention. Instead, I donate 10,000 rupees and that temple trust and authorities and all they have, like, they give me a receipt for this 10,000 rupees, which means they have to follow for which this fund is collected, for which this fund has to be utilized, and so on. They need to have accounts on that. In that case, a legal intention is created. So if this 10,000 rupees is not what used for temple construction or anything like that, then I can raise a question. Legal intention is created. So gifting, donation, you have to check whether legal intention is created or not. Okay. Next one, the whole of obligation, like there's a specific statute we have to follow, then go and follow that. If it is a tort, what do you mean by tort is it's a civil wrong. What do you mean by tort? Can please make a note of it? Civil wrong. Okay, let me have in the board. Tort is nothing but what you call as civil wrong. Examples of civil wrong is, so we were discussing about two laws, criminal law and civil law. Please try to remember all this. Criminal law, civil law. What do you mean by crime and what do you mean by then you go for cases like damages and compensation. Okay, let me go for like this. Why enters into a contract with X, okay, for selling a car, okay, for selling a car. Y delivers the car, X has to actually pay, X is not paying the amount, okay. This will be followed as civil law or criminal law? This will be followed as civil law, okay, because it's happening, see, it's very simple. Civil law means it's happening between the two parties, exclusively to between two parties. Let me go again. Y gets a loan from X. Okay, loan. Earlier it was the subject matter was car. Now it is a loan. Why does not okay? Why gives the loan? X does not pay the loan. What case is this? This again a civil law. Okay, this again a civil law. Now third case, X gets a loan from Y gets a loan from X gets a loan from X, but Y is a bank. Now, Indian Contract Act provisions will be applicable, but because it is a bank, we have to go and follow the banking regulation also. Here, the penalty will be raised and it will be called as a criminal. Again, you might be wondering why the same case here. Here it is civil law and here it is criminal law. How can you distinguish between the two laws? Very simple. When we talk about civil law, here we'll be talking about damages, we'll be talking about compensation. But whereas when we talk about criminal law, we'll talk about punishment, which is imprisonment, okay, and fine, so on. Penalty. We'll use a term called as penalty. Penalty is having two words equally, giving importance, imprisonment and fine. Fine is monetary penalty. Imprisonment means you are under somebody else's control. Okay. So depending on these things, you can clearly guess whether it's a civil law or criminal. Is it okay? Now coming back here. So civil wrong examples. Defamation is a civil wrong. What do you mean by defamation? Defaming. Okay, you talk about some wrong things about the actor, actors, some politicians. Okay, so you draw some pictures, caricatures. Okay, you do something, you damage the name. What do you mean by fame? Defaming, defamation cases. Another one example is I park my vehicle and I come inside my home. There is one another person who is a neighbor. He also parks my vehicle at my nearby gate. If I open the gate, then obviously it's hitting my bike and then it's hitting his bike. So I get tensed up and I can file a case. Whose road is that? Government's road. Okay, it's actually a government's road, but it's nearby my place. The fundamental right. I have the right to walk. If I'm placing my bike, then it's different. But if any other guy places the bike in front of my house, in front of my gate, then I can file a case. This is also parking. This is also a civil wrong. See, in this case, you can clarify this as criminal or civil, but the tort, it's called as law of torts. Here it clearly says defamation, parking, these are all are covered under civil law. And even there may be one person entering into a house during odd hours. Okay, odd hours means in between like 2 o'clock, 3 o'clock, late night. There is no authority for them to enter. Even a police cannot enter. Even a police, even we were discussing on income tax authorities, they cannot enter. Entering a house where there is an old lady alone, where there's a lady alone, we should not enter. Even the police. Only if they have the urgency, like they have the arrest warrant of somebody else, we can. Okay. Continuing. So the whole of obligation, like there is a separate statutes. What do you mean by statute? The spelling is statute. How you pronounce this is statute. Statute means law, act. It's a very wider definition having law, act, bill, or everything covered. Okay. Torts, civil wrong. Sometimes, even though it's followed or covered under Indian Contract Act, we take it for court and the judges give some judgment. Once the judgment is given, then never Indian Contract Act will be followed. Even though the judgment is not in terms of ICA or not in terms of ICA, that is Indian Contract. If the judgment is given, who is the judge there? He is the king, lawmaker. He is the lawmaker for that case. He has given the judgment. He has given the judgment, so everybody has to follow. Nobody can say, no, I'm not going to follow it because it's not there in Indian Contract. Okay. So these are not obliged. Obliged means you will not follow. And fourth one, yes, we know retrospective effect. No retrospective effect is applicable only from this date and not before. Is it okay? Can just go through this example. Now we'll just step into agreement. See, all this we have discussed in the earlier classes. Who are the two parties? Actually, we'll name the two parties here as one party offering will be called as offerer. Another party will receive the offer called as offeree. If that person accepts, will be called as the acceptor. So the person is offering, so offerer, the person is accepting, so acceptance. So the two parties means the two parties will be involved in some relationship with offer or acceptance. Second is consensus addendum. Three types we have: social, legal and void. Social means there is no legal consequences in terms of breach. What do you mean by breach? Means non-fulfillment of promise. If you want to make a note of it, yes, you can place Make a note of it. Non-fulfillment of promise. Fulfillment of promise. Non-fulfillment of promise. If you go to the court of law, the court cannot enforce. Okay. Legal, yes, legal consequences are there, and in case of any remedies, you can go to the court of law. Third, void. Actually, we'll discuss in the types of contract. We'll have illegal. You can please make a note here. You have illegal, okay, illegal and incapable. We'll discuss that bit later. Here, the definition is very clear. Void means not enforceable by law. It will be checked who is the person entered. He is not capable of entering during the contract. At the time of execution, not capable. While entering into the contract, not capable. So it's not enforceable by law. Likewise, illegal, not enforceable by law. Okay. See, India, as per Indian contract, it is not enforceable. Okay. See, I enter into a contract with you. Okay. I enter into a contract with you for the sale of opium. Okay. As per Indian Contract Act, we say this is void. But there are other acts which will punish me. If there is no legal consequences, we don't think that is not at all legal consequences will be levied. There will be applicability of other acts. As per Indian Contract Act, it will be concluded as no contract. It's a void one. But what's the subject matter? Opium. Opium without license. So obviously this will be carried on as a criminal case. Is it okay? Continuing. Next. So contract is nothing but a legal agreement. What do you mean by legal agreement? Agreement plus enforceability will be the legal enforceability. So when we started with same offer, there is another word equivalently we can call it as proposal also. It's between happening between two parties. So there is a significance, some movement happening from one party to another to do or not to do also. To do an act or not to do an act. Here's a case law where a person is constructing his house. You know the scaffolding, சாரம் கட்டுறது சொல்லுவாங்கல்ல, scaffolding. Actually, that scaffolding was not tied properly and it fell to the neighborhood house. And this person's compound was damaged. Immediately, he will go and claim to the neighbor, saying that because of this only damage, etc., etc. He will says, and he'll be saying that I'm going to the police station for filing the case and all. You're always disturbing me, building a house. See, sometimes it happens that the neighborhood house will be constructed long, will take a very long way, and it will be totally disturbed. Okay. So this guy, so let me name this as X and this is Y. So Y says I'm going to the court of law, etc., etc. Okay, this is a happened case. What X says here is, please don't go to the court of law. Instead, I will do the compensation. What's your problem? Your compound is damaged. I will construct the compound and I'll renovate the compound and beat. Immediately, Y accepts it, which means he's not going to the court of law. Is it okay? So, willingness to do or not to do also will be covered. So it's not only about positive actions happening, it's about non-happening of actions also will be considered. Only when this proposal or offer is accepted, then it becomes promise bound. Else it will not be called as a promise, which means the proposal has to be accepted. Okay, so this one particular content is over. Can you please go through? Continuing. Actually, when we talk about the essentials for a valid contract, we will be discussing 10 points. In this 10 points, 7 points will be discussed from the Act. Remaining 3 points will be discussed as essential needed for the supportive essentials. First point, agreement. Yes, we have already discussed. I'm taking up the speed. Minimum two parties should be there. Consensus addendum should be present. And we can refer this case law. This is State of Gujarat, Mrs. Ramanlal SNCO. Example, let me go for the second one. It's a beautiful example. X owned two horses per. One is black horse and the other one is white horse. He, who, X, offered to sell one horse to Y. While making the offer, this person had black horse in mind. But Y accepted thinking that it is made for, the offer is made for white horse. See, there is no mutual understanding. Understanding not in the same sense. So, no consensus agreement. Okay. Second, the concern without compulsion it should be, but in law will state here as the concern should be free and also genuine. What is this free consent? What is this genuine consent? We'll discuss later because there is a separate topic that we're going to discuss all these things. So let's discuss separately. Let me go for the example. X asked Y to sign in the documents threatening, which means what? There is some compulsion happening. If he would not sign, his son will be murdered. Okay, which means the consent is not free. So it cannot be a valid contract. For a contract to be a valid one, the consent should be free. Without compulsion, it should come from your end. Because, see, we say consensus addendum. When we say consensus addendum, obviously you're understanding what the contract is about. Then from your heart, you have to accept the contract. Okay, nobody can control. Third, competent or capacity. One is a minor cannot enter. Okay, it should be of major. That is attain the age of majority. And sound-minded, there should be the drunken person and all cannot enter. Again, we have a separate topic. We'll read that later. Fourth, consideration should be there and it should be from both the parties. Okay, let me go for this example. It's a beautiful example, very small and sweet example. X proposes to sell his house for 2 lakhs. See, earlier also we discussed this one, right? Here I'm using X proposes, there I was using X conveys his intention to. Okay. X proposes to sell his house for 2 lakhs. X agrees to buy it at 2 lakhs. It's very clear. There is a consideration for both the parties X and Y, which means what X gets, what Y gets. Actually, please try to understand what you mean by consideration first of all. What do you mean by consideration, Bob? Yeah, something in return. Anything in return, if I get it, then we say it's a legal agreement. The consideration should be lawful. Here, X is the owner of the house and Y is accepting the house for how much? 2 lakhs. Something in return, which means if X is giving the house, what X will get? 2 lakhs. See, consideration is 2 lakhs. Also, we say consideration is nothing but exchange of promises. If X is giving a promise for selling the house, Y is receiving the promise that he is going to get the house. In return, okay, what is X was getting? X was giving a promise, getting another promise. What is the another promise? 2 lakhs. We can call this as exchange of promises or anything. Okay, general term is exchange of promises. So something in return. So for consideration, for X, the consideration is 2 lakhs. For Y, the consideration is the house. Let me go for the next point. Lawful object. Yes, the object should be lawful. Let me go for this example. X promised to get Y appointed in a firm provided he pays him 1 lakh rupees. So some commission based and all. No, it's illegal, which is not lawful. Sixth, not expressly declared as void. See, as per my listing, I did this as a 10th point. You remember? So this was my 10th point. But here it is discussed as the last point under the essentials from the Act. This is the 7th point actually. Why this is the 7th point? I did not do the wrong numbering at all. I am asking why this is the 7th point. Because already we have minimum 2 parties and consensus and put together will be called as agreement. That's why when we talk about agreement, it is intentionally saying we have 2 points. So as per the numbering, if you check, it will look like 6 points, but here this is a 7th point, not explicitly declared as void. It's again a beautiful example. A and B contract to marry each other. Contract to marry each other, which is happening before the relationship comes as husband and wife. It's a valid contract. Okay. If it is happening during the relationship as husband and wife, we cannot say it's a valid contract because there is no legal relationship created. Before the time fixed for the marriage, A goes bad. So current status, not the current status. So what happens? No contract. Okay. It's not only during the time of entering, during the time of execution also you have to check. Okay. Other essentials which are considered as essentials, which means for first one, legal relationship should be there. You remember Balfour versus Balfour case? Mrs. Balfour files a case on Mr. Balfour regarding the maintenance amount has to be given and so on. We were discussing in the earlier class. Who won this case from? Mr. Balfour won. Because Mrs. Balfour and Mr. Balfour, the maintenance amount was discussed during the relationship as husband and wife. I asked you to refer this merit and merit case. Any idea? Did you refer? Okay, merit and merit case looks like a opposite of Balfour versus Balfour case. The same thing happens here, Mr. and Mrs. Merit. But the problem here is actually there is a misunderstanding between these two persons, husband and wife. And the husband will say that I will give you some maintenance amount. When this is happening? They did not go to the court of law, but when this happens, when this husband promises this, when the misunderstanding starts between the two persons. But what happens in the Bachelor versus Bachelor case? Mr. Bachelor has to go to some outstation for his project. He's leaving his wife and going, and for his wife's maintenance, he's promising, which is happening between husband and wife. A clear relation of husband and wife is defined. But what happens in the merit and merit cases? There actually stands a misunderstanding. After the misunderstanding has started, Mr. Merit promises Mrs. Merit that I'll give a maintenance compensation link. Okay. After that, he will not give the compensation and something will happen and this will go to the court of law. Who? Mrs. Merit. So this M is the lady, wife. Mrs. Merit goes to the whom? Okay. This is what you call as law. This is not act. Act means says what is what. Law means actually have to interpret. Here, when this contract happened, actually they're husband and wife only. They are not legally separated, but the misunderstanding has started. So the case was done in favor of the Mrs. Merit. So we can refer both Balfour versus Balfour and Mrs. Merit. Again, if you go for looking after some few points, just collect 4 or 5 points. That's enough. Okay. And example here, A, who is an oil merchant, sells 100 tons of oil to be a buyer, which means it's clearly mentioned who is A, oil merchant. The word itself says he is doing business on selling oil. It's very clear. So A and B creates legal relationship. Eighth one, legal formality. Yes, sometimes we have to go for registration, attestation, stamping, and other things and all. Ninth one, the last point, certainty and possibility of performance. Yes, it should be certain. This case law. A agrees to sell to B some garments. What is the some garments? There is no certainty. Certainty means exactly have to mention what type of garment. Okay, quality, quantity. If the terms and conditions are not certain, there is no certainty, which means uncertain. Here, next example, with respect to possibility of performance, A agrees with B to discover treasure by magic. The agreement cannot be enforced as it is not possible to be performed. Okay, treasure by magic. Magic is not real one, right? Probably you take this example. You give me some amount. Okay, I will print you cash and give. It will look like original cash. Okay, you can exchange and nobody will find out. Color note. Nobody will find out. Okay, I'll give you some 500 currency, rupees currency, 10 notes. You exchange it somewhere. Nobody will find it in case this is the situation. Okay, actually, this is possible, right? This is possible. Okay, any plans? This is possible, but what happens is law does not allow this, it becomes illegal. So, possibly is not just performing about action, what law says, what other authority says, everything has to be checked. Please join. Next, we'll go for the heading classification of contracts. What I'm going to do along with me here is we'll go for a chart work. Please have the heading as contracts. Okay. And we'll go for separation of the charts. Will you join with me? First one. Okay, first one, which is like the headings alone, the name of the contracts alone. First one, based on validity. Whether the contract valid? Okay, in that sense. When we talk about validity, actually we'll be using the terms void, void ab initio, okay, void ab initio, and voidable. Mostly we'll use these three terms only. We'll not use the term invalid. The main difference between void and void ab initio means from the beginning. It's a maxim. Okay, we use the legal maxim. What does it mean? Void ab initio. From the initial stage itself, it's void. Void means what? No, null, empty. The essentials 1 to 9, which I listed, 1 to 9, which I listed, right? You don't go for a single material, which I list, usually I list in this order. See, the 10th one, I take it as this one, not explicitly because all the other 9 points should be there. From the beginning itself, the 9 points or any one of the points is not there. Then you call this as void from the beginning. Okay, so void from the beginning. Okay, void from the beginning. So any one of the points among 1 to 9 is not present, then what happens? Void from the beginning. All of these 9 points are there, which means it happens to be a valid contract. but later it has become void. So 10th point. 10th point says what? All the 9 points should be valid during the execution also. Then in that case, we'll call it as void. Again, you can say whether it's illegal or incapable, whatever it is. If you go for incapacity, a minor cannot enter into a contract. What happens is, we'll talk about a lunatic person. Whom do you call as lunatic? Means some problem might have arrest, some mental strain where he cannot be normal sometimes, he can be normal sometimes. So when he is normal, it's fine. Probably a particular date he has entered into a contract where he was very capable, sound-minded person. And after that, he met with an accident, and during the execution, he loses his capacity. As we were checking with this, two people plan to marry A and B, and A goes mad. At the time of entering, he was perfect. Current state was perfect. But during the execution, it becomes void. So that's what you call as void. So whenever we use void, it has become void after that, after entering into the contract. Whenever we use the term void ab initio, any of the 1 to 9 points, they're not present. Because from the beginning it's void. What I mean by voidable is this voidable situation happens only in one case where the consent is not free or genuine. Here, we were checking one example, right? Which example was that X was asking to sign Y. If he is not signing, I think his son will be murdered. Whose son? Y's son will be murdered. So there is no option for Y. He has to sign the documents because actually he's been threatened. He has to sign the documents. In this case, where there is no option for Y, he signing the document. Looks like it's a valid contract, but in later period, if Y wants to move from the contract out, which means he can avoid the contract. Y has the option or Y will get the right to avoid the contract, but only if he starts only it will become avoidable. Here will not call void because void is something you say no or null. Here we use the term called as avoidable, that is voidable. So usually I ask you to refer this whenever you see this term, add a before that. How it looks? Avoidable form. So voidability. So we have these three. Usually we'll have these three. So first one, void. It's very simple, not enforceable by law. Next one, voidable. Okay, voidable means enforceable at the option of one party only, which means if the other party wants to move out of the contract, yes, but he has to prove that he has threatened me, no other go, I have to sign the documents, and so on. So, okay. Then illegal law forbids. Okay. Then unenforceable because of technical defects. Probably stamping is not done properly. Under stamping is done. Probably you have to do stamping with 100 rupees. Only 50 rupees is done. If the remaining 50 rupees is done, then the technical defect is removed. It's a defect. If it is removed, it becomes bad. Okay. I place a star mark because you cannot say it's void, but it's not valid. Okay. And valid or enforceable means all the essentials are present. Okay. Can you please list it out here? So in my chart, first one is on validity. Under that, subdivision, voidable. I'm not okay with the order. Voidable, void ab initio. Okay. So actually, I have not mentioned void ab initio over there. Unenforceable and valid. Illegal. Illegal. Okay. Okay. Shall I take over? Second heading. Okay. Now, we just want to discuss example over here. Yeah, this one. Mr. X agrees to write a book for the publisher. After a few days, X dies in an accident. There is no possibility of performance, right? When this is happening after a few days, which means contract is entered. It happens to be a valid contract. After that, it happens. That's why it's void. It's not void ability. Okay, this will do. This one only can just casually go through. Next heading. You can continue in the chart. How the contract is formed or how the contract is being created. You can say the contract is expressed and it's formed. So express contract or implied or inferred. Okay. What do you mean by express contract means? actually speak out, written or spoken. You send a mail. It will happen as a e-contract. Okay. X wrote a letter to Y. I am prepared to sell the car for 50,000 rupees. See, he's writing in letters. Probably in latest period, probably because of the technological development, we may be mentioning this as a mail. Okay. Wife also accepted the offer by a letter. It's a valid contract. And this contract is named as express contract. Second, because of some circumstances, it has implied saying that it's a contract. So implied or what you call as inferred contract. Inferred means we refer from the circumstances. So inferred contract from the circumstances of the case or from the conduct of the parties. I go to a restaurant and I take an ice cream, which means that I have to pay for the ice cream. It's understood, right? You go board a bus, which means you have to get the ticket. And there is one particular case where there's a subdivision of this. It's called as a tacit or silent contract. It's part of the implied contract. You can take the example, two examples. Cash is withdrawn by a customer from the ATM bank. So far, we are discussing that it's happening between two parties. But this is something happening with a mission and a party. But actually, it's not a mission, that's a banker. See, if you go enter the pin, enter the amount, you say yes, you say no, you say that withdrawal of amount, or you want to check the statement, whatever. What are the instructions you, and that machine is performing the instructions. So this is what you call as silent contract because of the action has been taken. Okay, so this is what you call as tacit or silent contract. Next one, there's something called as quasi contract. We say that if all the 10 essentials are followed strictly, then it becomes a valid contract. So far, we're discussing with SAC. What is quasi contract or what the term quasi means is, you can please make a note, it's called as half judicial, or you're not actually following the 10 essentials, so it's called as non judicial, which means because the access, we say it's a contract. Because the access, we say it's a contract. Let me go for the example directly, then I'll come for the above points. Here is a person, X is a tradesman, his business is trading. Left some certain goods at Y's house by mistake. Okay. Why? What he has to do? Actually, he has to call the person to get back the goods, but he treated the goods as his own. Obviously, Y is bound to pay for the goods because it's happening by mistake. There's no intention. See, what the contract says, if I'm using the goods, I should have bought the goods, which means that consideration should be there. I should have paid for the goods, then will become my goods, then I have bought the goods and I have used the goods. That's different. Here, Y did not place the order. X did not receive the order, which means what? There is no offer, there is no acceptance, there is nothing about consideration, nothing discussed, there is no essentials. But still, what law says? See now, it's created by law. Seems like there is nothing happened between the two persons, but law what says is it is a contract because Y is treating the goods as his own goods, which means at X cost he cannot leave. Whose amount is this? Whose goods is this? X goods. If he's paying for this, then he becomes the owner. But without paying, he's treating his own goods means obviously he has to pay for the goods. See, law treats everybody equally. You buy the goods, you use it because it's yours. Nobody will question it. Without buying the goods, how can you use others' goods? If you're arguing, it's by mistake he has given me what I can do. I did not ask him, but he has kept it in my house and went. So I'm using the goods. No. Law says no, you cannot do that. You cannot leave others first. Okay, so this is about the beautiful example. You can refer this. Actually, we have a separate topic for quasi contract. We'll go for other examples later. Next, we have EDI, that is e-contracts, electronic data interchange or cyber or mouse click for e-contracts. We have done this online purchasing and all. Okay, you might have bought medicines, you have bought dresses, or you might have made some online payments. Okay, you have registered for the course or whatever it is. Just a mouse click. Probably before that, you might have seen some tick box will be there, some declaration or something like that. You have to accept it, or or you give the declaration saying that I have read all the policies and terms and all. Only after it will go for payment page and all. Just a mouse click, contract is sent in. So that's why it's called as mouse click contract. It's all happening with the text. That's why we call this as e-contracts or cyber contracts or what. It's interacting with electronic agents. So the computer is programmed in such a way, if you want to execute, execute or stop it. Even though it's called as e-contracts, it should satisfy all the essentials of a contract through electronic means. Probably it will be linked with other networks through how electronic means. So you go for payment and it's been redirected to the bank page. If you want to make UPI payment, so it is directed to the page. Okay, so this is the second heading one. Shall we list it out here? What's the second heading? First is validate. Second is formation or creation. Yes, please join. Sorry, express contract. Okay. Implied contract or inward contract. Quasi contract. E-contracts. We have four. Okay. Shall I take over? Third heading. Depending on the performance. Two parties are entering into a contract. Both the parties have performed the contract. You call this as executed contract. You go to a tea shop, you buy a tea, the person serves the tea, you drink it or not, that doesn't matter. If you're buying the tea, means you're going to pay for the tea. You pay for the tea, he provides you, he serves the tea, then it's over. Cash fees. Wholly performed by both the parties. Second, executory contract, the other name is bilateral contract. Executory, which means both parties have to perform. Okay, I go to the tea shop, I order the tea is not yet arrived, I'm waiting for the tea. I have not yet paid, so payment is yet to be given, tea yet to be arrived, so both the parties have to perform. This is called as in future only they'll be doing it. So in future is another 5 minutes or 10 minutes, that's also future only. So it's what you call as executory contract. This is not happening or not yet happened between the two parties. Both the parties have not performed, so bilateral. So probably you might guess what is unilateral. One party perform, another party yet to perform. Okay. Then multilateral contract, actually this happens that there are more than two parties. Actually, it's very complex. When you go for international contracts, this will happen. Okay. So you can just make a note of this. What do you mean by multilateral? Okay. So here, the third listing, can you please help me out? Based on performance. Okay. Executed contract, see it's a past tense. Both over. Executory contract, which means both not happen. The other name for this is bilateral. Bi means two, right? Bi means two. Third is unilateral contract, which means partly executed. One part is executed and one other part is not executed, which means executory in each. Okay. Then we have multilateral contracts. Is it okay? That's about classification. Probably I think I have completed till here. In the next class, I'll discuss on this comparative study block. I request you to go through all these table. What do you mean by agreement and contract? The difference on what basis you're differentiating. So this is one classification, and one is about void and voidable. I have discussed almost everything. I just want you to refer. Okay, void and voidable. Then you have void contract and illegal agreement, and you have this is the fourth one. Void agreement and void contract. See, there's a difference between void agreement and void contract. You just go through and explain it. And I request you to go through all these problems. I think 11 problems will be there. Can you please check the number? 13, no? 13 problems are there. Probably I'll discuss some 4 or 5. I request you to go through everything. That will be helpful for writing purpose and all. I'll discuss with some 4 or 5, a few cases.